Affirmative consent legislation has passed the New South Wales Parliament in a major win for survivors of sexual assault. The changes require someone to do or say something to find out if their partner consents to sexual activity, and the laws will take effect mid-next year. Saxon Mullins has been campaigning for this outcome, and she joins me now in the studio. Saxon, we spoke 6 months ago when the Attorney-General announced this overhaul of the sexual consent laws. Now that they have passed, how does it feel?
I mean, it's unbelievable. We've sort of had this time to realise that it was happening with all the debates. But I think, if you think back 6 months ago, or even in 2018 when I came forward with my story, I would never have thought that we would be at this point. Props to the New South Wales Attorney-General for going further than the New South Wales Law Reform Commission recommended. And we're just really happy with how it's turned out. So
they've passed in a form that you wanted to see?
Yeah, absolutely. The Greens had put forward some amendments that we were happy with. Not all of them got passed, but I think the bill as it stands is really strong, and it really does show that affirmative consent is just common sense. And I think that was the prevailing message we sort of heard from all the MPs as they were discussing it, having their debates. It's just common sense. This isn't some crazy, outlandish thing that we all need to learn. It's just something we're already doing.
You said at the time that this 6-month lead time was really important. Why is that, and has that time been used well?
So I think the 6-month lead time is really important for making sure that the court officers, judicial officers, all of our police understand what the new laws are, so that when they are prosecuting these crimes or when it's going through our court system, it's done in the right way. So I think that is a really vital part of implementing any new law, but especially one where it does have those intricacies to it.
And education, of course, must continue. How has it been received so far?
Well, I mean, from what I can see, I think it's been received quite well. And I think it does have something to do with actually having these discussions around affirmative consent. So, I think the language of affirmative consent can kind of sound like a bit of legal discussion. So I think when we actually talk about it and defining what affirmative consent is, and it's not this, threshold that you have to meet, it's just having a conversation with someone that you want to engage in and act with and checking that they want to as well.
How will this change the prosecution of these cases?
I think fundamentally, and the thing that's really important for us is that it will shift that onus from what was the victim doing, why did this happen, to, well, if you want to say that you had an honest and reasonable belief, how was it honest and reasonable? How can you say it's reasonable if you haven't taken the steps to find out?
The New South Wales Attorney-General has said this is in fact a simplification of the law. It makes things clearer, easier to comply with. Some legal experts say it's fraught, though. They say that it'll potentially criminalise consensual sexual relations. Have those concerns that were voiced been allayed, or have they in fact gained momentum?
My favourite, New South Wales Bar Association. I think that, of course, there are questions. Whenever we change a law, how does this affect an accused? And that's not something that we're trying to diminish at all. That's a really important question. But we do not engage the law when there are consensual, happy encounters that people are having. I think when we're talking about a sexual assault trial, we are talking about an encounter where there has not been consent, or where someone has seen that there has not been consent. And so, I think just simplifying these laws and making sure that they're in step with having a conversation, I don't think that puts any place where it could potentially, put someone innocent in prison. I don't think that that's going to happen with how these laws have been set out.
Do you think victims and survivors will be emboldened to report sexual assault and also follow it through the courts in some cases?
I think so. I think, if the judicial system is someone's way of seeking that justice, I think this will help to alleviate at least some concerns about how we engage in these court procedures. Because, if you think you're going to go up there and be put on trial yourself, of course it makes you less willing to come forward. So if that's the path that they choose, I think we have made it even slightly easier to go through with.
Saxon, your decision to go public with your story has been the catalyst for this change. As you reflect on that decision now, has it turned out the way that you imagined at the time?
I think it's hard to say because, I came forward on Four Corners and the very next day the Attorney General announced these reviews. I almost didn't have a chance to think what this might look like. But, even in my deepest ponderings, I don't think I could have thought that it would end up so well. We have put a lot of hard work and hard time into it, and I think I'm just really pleased with how it's turned out.
Saxon, it's been a pleasure to have you in here.
Thank you so much.